The American legal system has been considering the environment's legal standing for at least 40 years. Although the Sierra Club has lost this particular case, Justice William Douglas's dissenting opinion in the 1972 Supreme Court case Sierra Club versus Morton paved the way for considering legal rights for the planet. Recognizing rights of nature and natural ecosystems is now the focus of a global grassroots movement with the help of a public interest law firm based in Pennsylvania called SELDAF, the Community Environmental Legal Defense Fund. Ecuador became the first country in the world to include rights of nature in its constitution. In less than a decade, more than 36 communities in the United States have passed local ordinances which recognize the rights of nature. If granting legal rights to something as vague as nature seems strange, consider the legal rights granted to another intangible entity, the corporation, as exemplified by the U.S. Supreme Court's decision in the Citizens United case.
Welcome to Crazy Town!
UC California law professor Christopher Stone drew an analogy between corporate rights and environmental rights in the 2011 reissue of his book, Should Trees Have Standing?
Yeah!
Justice Douglas based his 1972 dissent on the first edition of Stone's book. It can be argued that the rights of nature are more like human rights than the rights of corporations, which are artificial legal entities holding rights created by the courts. As it stands today, our environmental laws and regulations don't actually protect the environment. At best, they merely slow the rate of its destruction. The structure of law often gives corporations more power to make decisions in the communities in which they seek to do business. Thomas Lindsay, co-founder of SELDAF, says that the essence of the problem is that the law does not recognize your community or municipality has the authority to say no to a state or federal permitted process. The SELDAF strategy is to help communities enact ordinances asserting local sovereignty and proclaim local constitutions. Really, Bill of Rights. SELDAF has helped more than 150 communities in 8 states pass ordinances stripping corporations of the rights of personhood and recognizing the rights of communities to self-govern. On April 28th, Mora County, New Mexico became the first county in the U.S. to adopt the Community Bill of Rights. In their case, the issue was to ban fracking. The focus of an effort underway here in Lane County is to pass a local food sovereignty measure that asserts the right to a local food system and elevates our right to community self-government and local food systems above competing rights claimed by corporations. I represent a local movement called the Lane Community Bill of Rights that is supporting the effort to qualify this measure for, hopefully, the November 2014 ballot. If you'd like to participate in this effort, under this canopy right here, you can put your name down and contact information, and hopefully we'll see you at one of our meetings, or come out, give us your name, because we're going to need some signature gatherers. The tide is beginning to turn. The momentum is building. The Connecticut Senate has just voted 35-1 in favor of a GMO labeling bill, joining the Vermont House's 99-42 vote on a nearly identical measure earlier this month. In Maine, a GMO labeling measure has more than 120 bipartisan co-sponsors. In Washington State, a ballot measure known as Initiative 522 will be presented to voters in November, and it has a very good chance of passing.
Yay!